I'm here today to tell you about a subject that I get questions about frequently. In this video, I'll tell you what you need to know about protective orders and anti-stalking orders in the District of Columbia. I'm Morgan Lay, an experienced criminal defense and domestic violence attorney. Like this video and subscribe to my YouTube channel and Markham Law Firm's YouTube channel for more informational videos like this one. So what is a protective order or an anti-stalking order? A protective order and anti-stalking orders are court orders that last for up to 2 years that prohibit another person from contacting, attempting to contact, harassing, or stalking another person. The petitioner is the person who files a request for an order, and the respondent is the person who is served with the order. A protective order can also grant temporary custody of children to the petitioner and order the respondent to vacate the home if the parties live together. Violation of one of these orders is a criminal offense that carries jail time and financial penalties. So who's eligible for a protective order? To obtain a protective order, there must be a specific relationship between the petitioner and the respondent. The petitioner may file a protective order against a person who has committed or threatened to commit an intra-family offense against the petitioner, an act of animal cruelty against the petitioner's animal, sex assault, or sex trafficking. The petitioner must be able to show that there are reasonable grounds to believe that the respondent committed an intra-family offense. An intra-family offense is a criminal offense that has been committed against an intimate partner, a family member, or a household member, or as an offense punishable as animal cruelty against an animal that an intimate partner, family member, or household member possesses, owns, or controls. To be eligible for an anti-stalking order, the petitioner must show by a preponderance of the evidence that the respondent committed an act of stalking within 90 days of the filing of the petition. Stalking is defined in the D.C. Criminal Code as engaging in a course of conduct directed at a specific person with the intent to cause that person to fear for their safety or the safety of another, to feel seriously alarmed, disturbed, or frightened, or suffer emotional distress. Whether you file for a protective order or a stalking order will depend on the relationship between the petitioner and the respondent. What is a temporary protective order, and is a TPO always issued before a final hearing? The court may issue a TPO if the petitioner or person petitioning on the petitioner's behalf shows that the safety or welfare of the petitioner or their animal is immediately endangered by the respondent. A TPO will remain in effect for an initial period not to exceed 14 days. The court may extend a TPO as necessary to complete service and the hearing on the petition. If a judge declines to grant a TPO, but the court finds there's good cause to believe that the respondent has committed or threatened to commit an intra-family offense or animal cruelty, then a final protective order hearing will be scheduled. Are you entitled to see the other party's evidence before the hearing? Unlike a criminal case or a typical civil lawsuit, a party in a protective order proceeding is not automatically entitled to see the other party's evidence. A judge has discretion to order that evidence be produced upon motion of a party if it finds good cause to do so. So how do you get a protective order or an anti-stalking order? The first step in getting a protective order is to file a petition with the court. This can be done online through the court's website or in person. If the petitioner is requesting a TPO, they will appear before a judge the same day or the next business day to state why under oath they're requesting protection from the petitioner. If a TPO isn't granted or the petitioner isn't requesting one, then a final protective order hearing will be held within 14 days. So how long does an order last? A TPO can last for up to 14 days, and a final protective order or anti-stalking order can last for up to 2 years from the date the order was issued. So what should you bring to the final hearing? Regardless of whether you're the petitioner or the respondent, you should bring all evidence that tends to support your case. You should print out text messages, social media posts, emails, or other documents as opposed to trying to introduce them through your phone. Either party may call witnesses to testify on their behalf. What if you're accused of violating the order? Well, that would be a criminal offense, so you should immediately consult with an experienced attorney who can advise you of the criminal process and assist you in your defense. Don't make any statements to the police or anyone else, because anything you say can and will be used against you. So, are there any remedies if an order's been issued against you? Yes, there are. There are several remedies. Available if a protective order was issued against you. First, you can file a motion to modify certain terms of the order. You can request that the court reconsider its ruling by filing a written motion. If you didn't appear for the final hearing and an order was issued, you can file a motion to request that the court set aside the default order. A hearing is required to modify or set aside a protective order, but a court may decide a motion to reconsider its ruling without a hearing. A motion to reconsider must be filed within 28 days of the issuance of the original order. So, do you need a lawyer to file for a protective order or defend against one? A lawyer isn't required, this is a civil proceeding, but hiring a lawyer can be very helpful in understanding the process and the consequences. A lawyer can negotiate with the opposing party and use their knowledge of the rules of evidence at the contested hearing. A lawyer can reduce stress by guiding their client through the entire process, from filing a protective order to serving a protective order to defending against one. Protective orders can have serious consequences for a respondent, especially if the respondent shares a home or children with the petitioner. In addition, protective orders can be a problem if the respondent has a security clearance for their job. If a protective order has been issued against you, it is also unlawful for you to possess firearms during the duration of the order. I hope that you found this video useful. Please like and subscribe to my YouTube channel and Markham Law Firm's YouTube channel for more informational videos like this one. Thank you. I'm Morgan Lay, and I'll see you next time.